Lawyers of Reddit, when did you regret taking the case immediately? Story 1. The Victim's Compensation Paradox. Picture this: a state-funded program designed to help crime victims recover from their trauma. Simple enough, right? The state pays victims for their suffering, then makes the criminals pay it back. Beautiful system. Elegant, even. Enter my client, stage left, dragging his bruised ego and a fundamental misunderstanding of cause and effect. This gentleman had just finished his assault trial. Guilty verdict, naturally. He'd taken his frustrations out on several family members, leaving them with both physical and psychological scars. The judge ordered him to repay the victim's compensation fund. Standard procedure. But here's where our protagonist's brain performed an Olympic-level mental gymnastics routine. He sat in my office, adjusting his ill-fitting suit, and laid out his master plan with the confidence of someone who'd invented electricity. "So, I'm a victim too," he announced, leaning forward conspiratorially. I blinked. Waited. Sometimes silence reveals more than questions. "This whole trial thing," he continued, waving his hands like he was conducting an invisible orchestra, "it's been traumatic. The stress, the lawyers, having to sit there while people talk about what I allegedly did." "What you did," I corrected. "What I allegedly did to my cousins. That's psychological injury right there." The man genuinely believed, and I cannot stress this enough, that being convicted of assault qualified him for victim's compensation from the same fund he was ordered to pay into. He wanted the state to pay him for the trauma of the state making him pay for traumatizing others. I spent the next 45 minutes drawing diagrams. Actual diagrams, with arrows, big ones pointing from "you assault people" to "you pay money," and definitely not pointing towards "state gives you money." But here's the beautiful part. He wasn't done. Oh no, our hero had workshopped this theory. "What if we argue that I'm traumatized by having to pay? That's a new trauma, fresh trauma. Surely that counts." I had to explain, using words typically reserved for explaining why water is wet, that you cannot claim compensation for the consequences of your own criminal actions. You cannot punch someone and then sue your fist for hurting. You cannot rob a bank and claim PTSD from carrying all that heavy money. The man left my office convinced the system was rigged against him, which in a way it was. Rigged against people who assault their relatives and then expect a government check for their troubles. Some days, I genuinely wonder if law school prepared me for this. Torts? Yes. Criminal procedure? Absolutely. Explaining why crime doesn't pay you? That must have been the day I was sick. Story 2. The Gun-Waving Employee Protection Act. Corporate law usually involves spreadsheets, contracts, and the occasional hostile takeover. What it doesn't usually involve is me having to explain the basics of actions have consequences to a grown adult who owns a business. My client called me in a panic, full theatrical panic, heavy breathing, dramatic pauses, the works. "I think I'm being sued for wrongful termination," he gasped into the phone. Now, wrongful termination cases can be tricky. Protected classes, discrimination, retaliation, lots of legal landmines. I prepared myself for a complex situation requiring delicate navigation. "Tell me what happened," I said, pulling out my legal pad. "Well, I fired Johnson last week." "Why did you fire Johnson?" "That's the thing. My other employees are saying I can't fire him just because of what happened."
Red flag. Big, waving, communist parade-sized red flag. What happened? Okay, so Johnson took about $8,000 from the safe, but that's not the main thing. $8,000 from the safe, but that's not the main thing? I felt my law degree crying softly in its frame on the wall. The main thing is that when Stevens asked him about the missing money, Johnson pulled a gun on him. I set down my pen. He pulled a gun on a coworker? Right, but Stevens wasn't hurt, so was there more? Well, yes, Mrs. Henderson came in to pick up her order, and Johnson was still holding the gun, and he might have pointed it at her, accidentally, while gesturing. Gesturing with a loaded weapon at a customer. She said he was waving it around while explaining that the register was broken. Very animated explanation. But here's the thing, it's all on camera, crystal clear, so I have proof. Here's where I realized my client had somehow confused evidence of multiple felonies with reasons you can't fire someone. Let me understand, I said, rubbing my temples in a way that would become habitual during our meetings. You think you can't fire Johnson because? Because it's his first offense at our store that we know of. Plus, he's been here 6 months. Doesn't he have some kind of tenure? Tenure? The man thought retail employees achieve tenure like university professors, apparently granting them immunity to commit armed robbery. I had to explain, and this is verbatim from my notes, that yes, you can fire someone for 1. Stealing significant sums of money, 2. Threatening coworkers with deadly weapons, and 3. Traumatizing customers with impromptu gun displays. But what about progressive discipline? My client asked. Shouldn't I give him a warning first? A warning for armed robbery? Dear Johnson, please consider this your first written warning regarding bringing loaded firearms to work and pointing them at people while stealing. Next time, we'll have to escalate to a stern talking to. The real kicker came when I asked if he'd called the police. No, he said, I didn't want to get Johnson in trouble. The man had security footage of grand theft and assault with a deadly weapon, and his main concern was whether firing the perpetrator might violate some imaginary employment law that protects gun-waving thieves. I drafted a very simple letter explaining that, shockingly, employers can indeed terminate employees who commit multiple felonies on camera during business hours. Revolutionary concept, I know. Johnson never sued, probably because he was too busy dealing with the criminal charges that mysteriously appeared after an anonymous tip to the police included some very specific details about some very specific security footage. My client still calls occasionally, asking if he can fire employees for various obvious reasons. Last week, can I fire someone for setting the break room on fire? Yes. Yes, you can.
The Florida Supreme Court has seen many things. This particular day, they saw something special. A legal argument so circular it could have been used to demonstrate perpetual motion. Our defendant, a gentleman with a baseball bat and anger management issues that would make the Hulk suggest therapy, had ended several lives in particularly brutal fashion. The evidence was overwhelming. The conviction was swift. The sentence was harsh. But wait, our legal virtuoso had an ace up his sleeve for the appeal. Your Honors, his attorney began, presumably while internally screaming, my client suffers from severe PTSD. The justices leaned forward. PTSD can indeed be a mitigating factor. Military service, childhood trauma, surviving a disaster.
The PTSD, the attorney continued, his voice carrying the weight of someone who'd lost multiple arguments about this already, stems from the traumatic experience of committing these murders. The silence in that courtroom was so thick you could have carved it up and served it at Thanksgiving. One justice, bless his heart, sought clarification. "Counsel, are you arguing that your client has PTSD from murdering people and that this PTSD should reduce his sentence for murdering those people?" "Yes, Your Honor. The act of beating multiple individuals with a baseball bat was deeply traumatic for my client." I imagine somewhere in that courtroom, Lady Justice didn't just peek under her blindfold, she ripped it off entirely to make sure she was hearing this correctly. The defendant himself jumped in because apparently his attorney wasn't digging the hole fast enough. "You don't understand what it's like," he exclaimed. "The sounds, the screaming, having to swing that bat over and over. My arms were so tired, and the blood got on my favorite shoes." The court had to explain, and this is public record, that mental trauma acquired while committing a crime cannot be used to mitigate the sentence for that crime. Otherwise, every criminal would be entitled to reduced sentences for the trauma of their criminal acts. "But I have nightmares," the defendant protested. "About what you did?" "Yes." "To other people?" "Yes." "With a baseball bat?" "It was aluminum, very lightweight. My wrist still hurt." The justices delivered what might be the most patient explanation in legal history. You cannot claim victim status for being the perpetrator. You cannot seek remedy for self-inflicted wounds, especially when those wounds are guilty conscience dressed up in medical terminology. The defendant's final argument? He claimed the state had traumatized him by making him relive the murders during trial. The same murders he was arguing gave him PTSD, which he wanted considered as mitigation for the murders. If you're confused by the circular logic, congratulations, you're more qualified to practice law than this defendant was to make legal arguments. Appeal denied. Sentence upheld. And somewhere in Florida, law students still study this case as example A of how not to make an argument. Though I hear the defendant is now claiming he has PTSD from losing his appeal. He's considering appealing the appeal. The circle of legal life continues.
Story 4. The time-delayed self-defense strategy. Legal concepts can be tricky for some people. The idea of self-defense, for instance, seems pretty straightforward. Someone attacks you, you defend yourself in that moment. Simple, clean, immediate. Then you get my client, who apparently thought self-defense operated on the same timeline as an Amazon Prime delivery. He sat in my office and explained, "So he punched me in the face," pointing to a spot on his cheek that had long since healed. "I'm sorry that happened," I said. "When did you defend yourself?" "Last night," he announced proudly. I paused. I checked my calendar. Then I checked it again. Now, math was never my best subject, but even I could count to 14. "The assault happened 2 weeks ago?" "Yeah," he said. "I had to plan my defense properly." This man, this grown adult man with a driver's license and the right to vote, had spent 2 full weeks meticulously planning his self-defense. He told me he'd made charts, he'd drawn diagrams. I suspect he may have even built a scale model of the encounter, though he thankfully didn't bring any visual aids to our meeting. I took a deep breath. "Walk me through your defense." "Well," he began, "I waited for things to cool down, for the tactical advantage. Then, last night, I went over to his house." "You went to his house?" and I rang the doorbell, like a gentleman. You rang the doorbell? And when he answered, I kicked the absolute stuffing out of him. Self-defense. The look of genuine satisfaction on his face was something to behold. This man truly believed he'd discovered a loophole in the space-time continuum of criminal law. I pulled out my legal pad and drew a simple timeline. On day 1, I put a big X and wrote initial assault. Then I drew 14 little hash marks for the days that followed. At the end, I put another X and wrote your defense. This, I said, pointing to the first X on day 1, is the window for self-defense. But I wasn't ready then, he protested. Self-defense isn't something you schedule, I explained. It's not a dentist appointment you can book for a later date. But he hit me first, 2 weeks ago. Doesn't that make everything that follows self-defense? By his logic, every bar fight in history could ignite a decades-long vendetta, all legally protected under the magical umbrella of delayed self-defense. Ancient family feuds could be settled with simple paperwork. Your Honor, his great-grandfather stole my great-grandfather's parking spot in 1924. This is clearly self-defense. What you did, I said, using the patient voice I typically reserve for explaining why you can't sue the weather, is called assault. And given your 2-week planning period, it's very likely premeditated assault. But I was defending myself. From what? His doorbell? Were you afraid he might answer the door at you too aggressively? The man left my office genuinely confused, muttering about the unfairness of temporal restrictions on what he considered justice. He eventually pled to simple assault. It honestly could have been worse. I think the prosecutor was joking, but he did mention wanting to add charges for breaking and entering onto a porch with intent to commit doorbell ringing. It's just another day in the legal system where common sense often goes to die, and time travel is not, in fact, a valid defense strategy.
Some days you question your law degree. Other days you question humanity itself. This was both. My client arrived 15 minutes late, flustered and sweating. "The stairs!" she gasped. "So many stairs!" "We're on the 4th floor. Didn't you take the elevator?" Blank stare, the blankest stare. A stare so blank it could have been used as printer paper. The what? And that's how I, a licensed attorney with substantial student loans and a working knowledge of constitutional law, found myself explaining elevator technology to a grown woman. "It's like a moving room," I began, already regretting my career choices. "You press a button, the doors open, you step inside." Inside what? The box, the metal box. And then? You press the number 4, because we're on the 4th floor. How does it know? There are cables and pulleys. Look, the important thing is you press 4. Then what? The doors close, the elevator moves up, a light shows you're on floor 4, the doors open, you exit. She took notes. Actual notes on elevator operation. I watched her write PRESS4 in large letters. But wait, the universe wasn't done testing me. This same client, this elevator-challenged individual, had come to me with a family law matter that would make Solomon weep. "I want to terminate my parental rights," she announced. "Okay, that's a serious decision, but I still want to see my kid on weekends." Record scratch, freeze frame. This is where I realized that explaining elevators was going to be the easy part of our meeting. You want to legally declare you're not the parent, but still visit like a parent? Exactly, like joint custody, but without the responsibilities. She'd invented a new form of quantum parenting, simultaneously being and not being a parent, existing in a legal superposition until observed by Child Protective Services. That's not... You can't. Parental rights aren't a Netflix subscription you can pause and unpause. Why not? Why not? Because words have meanings, Karen. Because legal concepts aren't Build-A-Bear workshops where you customize your obligations. Because terminating parental rights means you're legally not the parent. No visits, no decisions, no anything. But I'd still be the birth mother. Biologically, yes. Legally, no. What's the difference? I drew another diagram. So many diagrams. My legal pad looked like a kindergarten workbook. This circle is biological parent. This circle is legal parent. When you terminate rights, you erase this circle. I dramatically crossed out the legal parent circle. But I still want weekends. From which circle? The mom circle? There is no mom circle after termination. That's what termination means. It's in the name. Terminal, final, done. She left convinced the system was discriminating against her innovative approach to selective parenting. Probably took the stairs down, too. Later that week, she called. I figured out the elevator, but it took me to the basement. Is that self-defense? I hung up. Some questions don't deserve answers. There's a special folder in my filing cabinet labeled Clients Who Thought I Was a Charity. It's substantial. So, when do we start? She asked, settling into my office chair like she owned it. As soon as we discuss my retainer and hourly rate. The look she gave me? Like I just suggested we sacrifice a goat in the conference room. Pure, undiluted shock. Your what? My fee for legal services. Fee? Yes, money, currency, legal tender, the stuff you exchange for goods and services. But you're my lawyer. Yes, and lawyers charge for their services. Since when? Since approximately 3000 BCE, when the first Mesopotamian attorney charged 2 goats and a bushel of wheat for arguing about water rights. But I kept that historical tidbit to myself. I thought lawyers were like public servants? That's a public defender. Did you commit a crime? No. Then I'm a private attorney. Private means... I know what private means. I just thought, you help people. I do help people for money. She looked around my office, apparently noticing for the first time that it wasn't a soup kitchen with law books. The leather chairs, the mahogany desk, the diplomas that cost more than some houses. But isn't this your calling, your passion? My passion is eating food and living indoors. Both require money. This feels very transactional. That's because it's literally a transaction. She pulled out her phone, probably to leave me a 1-star Yelp review for practicing capitalism. My sister's lawyer didn't charge her. Was your sister's lawyer her husband? Yes. Mystery solved. The mental gymnastics were Olympic level. She genuinely believed lawyers existed in some alternate economy where we sustain ourselves on good intentions and the satisfaction of resolving contract disputes. What about pro bono? She asked triumphantly. I do pro bono work for indigent clients. You drove here in a Mercedes. It's a lease. Still a Mercedes. But I really need help with this case. And I really need to pay my mortgage. See how needs work? She left in a huff, probably to find another lawyer who would work for exposure or positive vibes or whatever currency exists in her fantasy economy. 2 weeks later, she called back. "I've thought about it, and I'm willing to pay you." "Wonderful. My retainer is in installments, over 30 years, without interest, starting next decade." I hung up. My fairy godmother services were needed elsewhere, specifically at the bank, where they only accept actual money.
Story 8. The Sober Window Jump Defense. Physics, gravity, blood alcohol content. These are simple concepts that shouldn't require legal interpretation. Yet here we were. "I was completely sober," my client insisted. "When you jumped out of a third-story window?" "Stone cold sober." "With a beer bottle?" "For balance." "And threw it at a police officer?" "He startled me." Let's paint this picture. 2 a.m., third-floor apartment. My client, allegedly sober, decides the window is a better exit than the door, takes his beer bottle, for balance, remember, and executes what witnesses described as a graceless belly flop onto reality. Upon landing, miraculously with only minor injuries, he spots a police officer. The officer, probably wondering why it's raining idiots, approaches to help. My client's response: threw the beer bottle at him. "I wasn't drunk," he insisted for the 100th time. The jury won't believe that. Why not? Because sober people use doors. The door was so far away, 15 feet. The window was a 30-foot drop. But it was a straight line. This man had invented a new form of geometry where the shortest distance between 2 points involved gravity and potential death. "Listen," I said, employing my dwindling patience reserves, "I need you to understand something. No jury in the history of American jurisprudence will believe a sober person jumped out of a third-floor window at 2 a.m. while holding a beer bottle. But I can explain the physics." "Please don't." He did anyway. Something about wind resistance and optimal trajectory and how beer bottles are actually aerodynamically superior to empty hands. It was like listening to a drunk Isaac Newton explain why apples fall up. "Also," I added, "you threw the bottle at a cop. He surprised me. By existing? By being where falling idiots might land? I thought he was a robber. In full uniform? Clever disguise." The man was either the world's worst liar or genuinely believed his own alternate reality. Either way, the prosecutor had security footage, 12 witnesses, and a beer bottle with his fingerprints. "Look," I said finally, "I think you were drunk." "Based on what?" "Based on you jumping out of a third-story window with a beer bottle and throwing it at a cop. That's circumstantial. That's basically a confession written in behavior." We went to trial. He insisted on testifying, explained his sober window-jumping theory to 12 increasingly incredulous jurors, even drew diagrams. The prosecutor didn't bother cross-examining, just played the security footage on loop. Guilty. Shocked Pikachu face from my client. But I explained the physics. The physics of drunk decisions, maybe. The judge wasn't interested in his theories of gravitational sobriety. Sentencing was lenient considering community service, alcohol education classes, and a restraining order keeping him away from third-floor windows. He still calls occasionally, still maintains he was sober, still has new theories about aerodynamics. Still uses doors now, though. Funny how criminal conviction improves your relationship with conventional exits. Story 9. The meth-adjacent romance defense. Some conversations make you question your career choices. This one made me question evolution. "So I don't smoke meth," my client began. Good start. Excellent even. The bar was so low it was basically a speed bump, but he'd cleared it. "The positive drug test says otherwise." "That's what I'm explaining. I don't smoke it." "Then, unprotected sex." I set down my coffee. It was too early for this. It would always be too early for this. You're saying you tested positive for methamphetamines because of unprotected sex? Exactly! Cross-contamination. This man had invented a new STD, sexually transmitted drugs. Medical journals would be fascinated. So, to be clear, I said, rubbing my temples in what was becoming a permanent gesture, you want me to tell the judge you don't use meth, you just have unprotected sex with people who do? Yeah, shows I'm responsible. How does that show responsibility? Because I don't do drugs. I'm drug-free. But you're having unprotected sex with active drug users? Don't judge my lifestyle. I wasn't judging his lifestyle. I was judging his understanding of both chemistry and legal defenses. The judge will ask follow-up questions. Like what? Like how methamphetamines transfer through intimate contact. Body fluids. That's not how meth works. Maybe it's a new kind. Of meth? Of sex. This conversation had derailed so spectacularly that the original tracks were in a different time zone. Sir, even if, and this is a huge if, the judge believes you absorbed meth through unprotected sex, that's not better. That's arguably worse. How is being drug-free worse? You're not drug-free. You're drug-adjacent. You're drug-curious through proximity. But I never smoked it. The test doesn't care about your consumption preferences. He genuinely thought he'd found a loophole, like the law had a special exemption for second-hand meth acquired through poor romantic choices. What if we get character witnesses, he suggested, to testify about what? Your selection process for intimate partners? To say I don't smoke meth. But you test positive for meth. Through sex. We'd come full circle. The snake of logic was eating its own tail while high on secondhand methamphetamines. I drafted the most professionally worded motion of my career, essentially saying, my client claims he's not a drug user, just someone who makes questionable romantic choices with drug users, which he believes is totally different. The judge's face during the hearing was a masterpiece. Disbelief, confusion, and resignation all fighting for dominance. Counselor, the judge said slowly, is your client seriously arguing that he should avoid drug charges because he only associates intimately with drug users? That's essentially his position, Your Honor. And he thinks this is better? He does, Your Honor. Why? I've been asking myself that for weeks, Your Honor. Plea deal, probation, drug tests, and probably some very awkward conversations about safe sex that nobody in law school prepared me for. The client still doesn't understand why his defense didn't work, calls it discrimination against his alternative lifestyle. I call it Thursday in criminal defense.
Story 10. The Cocaine Entrapment Conspiracy. HR departments exist for a reason. That reason is usually to prevent lawsuits. Sometimes it's to prevent physics-defying lawsuits that redefine the concept of entrapment. I want to sue my boss, my client announced. For entrapment. Entrapment, a legal concept so misunderstood it should come with a mandatory education course. Tell me what happened. Okay, so I was at my desk, at work. Yeah, at work. And I was just doing a line of cocaine, but just a small one. You were doing cocaine? At your desk, at work. It was a stressful day. Already, we'd ventured beyond normal legal territory into the realm of how are you still employed? Continue. So my boss walks in while you're actively snorting cocaine? Right, no warning, just barges in. To his own office building? Exactly, and he sees me with the cocaine still on my desk. How much cocaine? Visible amounts. And then he sends me for a drug test. The man paused,
waiting for my outrage, waiting for me to slam my fist on the desk and declare this injustice would not stand. That's what employers do when they find employees doing cocaine at work. But it's entrapment. How? He tricked me. Into doing cocaine? Into getting caught. This man believed entrapment meant entering a room at an inconvenient time for criminal activity. By his logic, every burglar caught mid-burglary was entrapped by homeowners who rudely returned home. Sir, entrapment requires law enforcement to induce you to commit a crime you wouldn't otherwise commit. Your boss isn't law enforcement. He acts like it. And he didn't induce you to do cocaine. The stress did. And walking into his own building isn't trickery. He didn't knock. On his own office? Common courtesy. I pulled out my trusty legal pad, drew a stick figure doing cocaine, drew another stick figure labeled boss walking through a door, drew an arrow labeled not entrapment. This is you doing crimes. This is your boss existing in his own space. This is why you can't sue. But the drug test is legal and reasonable and honestly redundant since he saw you doing cocaine. What if I say it was powdered sugar? Was it? No. Then don't. What if I say I thought it was? You thought you were snorting powdered sugar for stress relief? Yes. The man had committed to a defense that required him to be either the world's most dedicated baker or the world's worst drug user. Even if the judge believed you, which they won't, snorting powdered sugar at work is still fireable. Why? Because it's insane behavior, but not illegal. Neither is wearing a tutu to work, but they can still fire you. He left my office convinced the system was rigged against recreational workplace drug use, which, to be fair, it absolutely is. No lawsuit was filed, probably because he was too busy job hunting to pursue his groundbreaking entrapment theory. Last I heard, he was working from home, probably safer for everyone involved. Like what? Like how methamphetamines transfer through intimate contact, body fluids. That's not how meth works. Maybe it's a new kind. Of meth? Of sex? This conversation had derailed so spectacularly that the original tracks were in a different time zone. Sir, even if, and this is a huge if, the judge believes you absorbed meth through unprotected sex, that's not better. That's arguably worse. How is being drug-free worse? You're not drug-free. You're drug-adjacent. You're drug-curious through proximity. But I never smoked it. The test doesn't care about your consumption method preferences. He genuinely found a loophole, like the law had a special exemption for second-hand meth acquired through poor romantic choices. What if we get character witnesses, he suggested, to testify about what? Your selection process for intimate partners? To say I don't smoke meth? But you test positive for meth. Through sex. We'd come full circle. The snake of logic was eating its own tail while high on second-hand methamphetamines. I drafted the most professionally worded motion of my career, essentially saying, my client claims he's not a drug user, just someone who makes questionable romantic choices with drug users, which he believes is totally different. The judge's face during the hearing was a masterpiece. Disbelief, confusion, and resignation all fighting for dominance. Counselor, the judge said slowly, is your client seriously arguing that he should avoid drug charges because he only associates intimately with drug users? That's essentially his position, Your Honor. And he thinks this is better? He does, Your Honor. Why? I've been asking myself that for weeks, Your Honor. Plea deal. Probation, drug tests, and probably some very awkward conversations about safe sex that nobody in law school prepared me for. The client still doesn't understand why his defense didn't work, calls it discrimination against his alternative lifestyle. I call it Thursday in criminal defense.